Welcome to the deep dive. Today we're tackling a really tricky part of contract law, the statute of frauds. Our mission is to figure out exactly when an agreement absolutely has to be in writing to hold up in court.
Yeah, it's a critical area because the statute of frauds, well, it walks this fine line. Historically, it was meant to stop people lying under oath, prevent false claims about contracts that never happen.
Right.
But today, it often acts like this giant loophole, a way for someone to wiggle out of a real, honest oral agreement just because the paperwork isn't perfect.
That tension, that's what makes it so confusing, isn't it? Protection versus, well, a potential escape hatch.
Exactly.
So for you listening, if you're facing a statute of frauds issue, there's a clear three-step process you need to follow right from the start.
That's right. To figure out if that oral contract is enforceable, you've got to ask 3 questions, and in this specific order. First, is this contract actually within the statute of frauds? Does it fit into one of those categories that require writing, like land sales, suretyship, or the one we'll focus on, contracts impossible to perform within a year?
Okay, step 1. Is it covered? If the answer is yes, then what's step 2?
Step 2 is, okay, maybe there is some writing. Is it sufficient? Does it, lay out the essential terms? Does it show a contract was actually made? And crucially, is it signed by the person you're trying to enforce it against? The party who's resisting.
Signed by the party to be charged.
Yep.
Got it. And if there's no writing, or is not good enough?
Then you hit step 3, does a major exception apply? And today we're zeroing in on 3 really common, often confusing areas. There's the 1-year rule, which sounds simple but isn't. Then suretyship, promising to cover someone else's debt, and its important main purpose exception. And finally, the UCC's special rule for merchants, the confirmatory memo.
Perfect. Let's dive right into that 1-year rule. It seems straightforward. Contracts over a year need writing. But you mentioned courts interpret it very narrowly. What's the actual rule, and what does incapable really mean here?
Okay, the general rule is contracts that are incapable of being fully performed within 1 year from the date the contract was made must be in writing. And the key word is incapable. If there's any theoretical possibility, however remote, that performance can be completed within 365 days, then the agreement is outside the statute. No writing needed.
Whoa. So it's not about what's likely or even physically possible. It's about legal possibility.
Precisely. It's a very strict test.
Let's make that concrete. You used this example before, the Empire State Building. If I hire you today, orally, to build a perfect full-scale replica, obviously taking years, does that need writing?
Surprisingly, no.
No.
No, because the contract terms don't explicitly require it to take more than a year. You, the builder, wouldn't be breaching the contract if somehow, miraculously, you finished in 11 months.
Well,
So, because early completion isn't a breach, it's legally capable of performance within a year. Physically impossible, sure, but legally, it's outside the statute.
that really highlights how narrow this rule is. Okay, let's apply this possibility versus probability idea and this critical distinction between performance and excuse to a real scenario. Let's use the nursing home hypothetical.
Good example. Let's break it down.
Okay, the facts are, Comfort Arms Nursing Home makes an oral agreement to care for Betty, and the key term is, for a minimum of 18 months. Let's analyze this using our structured method. First, what are the legally dispositive facts?
The crucial facts are: 1, the contract requires a minimum duration of 18 months of care, and 2, the clock starts ticking from the moment the agreement is made.
And what was the core legal issue?
The issue is whether this fixed-term contract, which clearly goes beyond a year, can be pulled outside the statute of frauds because of something like, well, the possibility of Betty dying within that first year. Does death count as performance here or just an excuse?
What rule of law did the court apply? Can you state the full black-letter rule and break down its testable elements for us?
Sure. The rule is that the contract, by its own explicit terms, must require performance to extend beyond 1 year. It's only within the statute if it's incapable of performance within that year. So there are really 2 elements. First, the contract terms must set a mandatory performance period. And second, that mandatory period must extend beyond 1 year from the contract's formation date.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the mandatory performance period?
Well, the contract was explicit. It said a minimum of 18 months of care. That's not at will. It's not for life. It's a fixed mandatory duration. So element 1 is clearly met.
Understood. Now, what about the second element, performance beyond 1 year? How did the court handle the possibility of Betty's death within the first 12 months?
This is the crucial part. The court said Betty dying early doesn't satisfy the second element in this case. Her death wouldn't mean Comfort Arms had fully performed the 18-month obligation. Instead, death would simply give Comfort Arms a legal excuse for not completing the remaining months. It excuses non-performance. It doesn't constitute performance of the full 18 months promised.
Ah, okay, so the distinction is key. If the contract had been care for Betty for life, she could die within the year, fulfilling the terms. That would be outside the statute.
Exactly.
But because this one demanded 18 months, death only excuses the rest. The 18-month term itself is incapable of being performed in 12.
Precisely. Because the contract mandates 18 months, it's legally incapable of performance within a year.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded the agreement falls within the statute of frauds. It needs to be in writing to be enforceable because performance, according to its explicit terms, requires more than 1 year. That performance versus excuse distinction is absolutely vital for the 1-year rule.
That clears it up significantly. Okay, let's shift gears. We've tackled timing. Now let's look at promises made out of caution, or maybe obligation. The suretyship category, promises to answer for the debt of another. Why does the statute specifically target these?
Right, suretyship involves 3 parties: the debtor, the creditor, and the surety, the one promising to pay if the debtor doesn't. The statute singles these out primarily for a cautionary function. Often the surety isn't getting much tangible benefit. Maybe they're helping family or a friend, acting out of, love and affection. The writing requirement forces them to pause and recognize the seriousness of becoming legally obligated for someone else's debt. So the general rule, suretyship contracts need to be in writing.
Okay, that makes sense from a protection standpoint. But there's a major way around this, the main purpose exception. If the goal is to protect the surety, why allow this exception for oral promises?
Well, the exception kicks in when that core rationale protecting a potentially naive or altruistic promiser disappears. If the surety's main purpose, their leading object in making that promise was actually for their own economic advantage, then they don't really need the statute's warning. They're acting in their own self-interest. In that case, the oral promise is taken outside the statute and can be enforced.
Got it. So if they stand to gain personally, the law assumes they knew what they were doing. Let's test this with the case Murtis v. Underwood. The facts here involve the defendant, who was the controlling shareholder of a company. He orally promised one of the company's creditors that he personally would repay a debt the company owed.
Okay, let's analyze Murtis. First, what are the legally dispositive facts? Key facts. Defendant is the controlling shareholder. He makes an oral promise directly to a creditor of the corporation he controls, promising to cover the corporation's debt. Looks like a classic surety situation on the surface.
And what was the core legal issue?
The issue was whether this oral promise by the shareholder was barred by the suretyship provision of the statute of frauds, or if it fell under the main purpose exception, making it enforceable despite being oral.
What rule of law did the court apply? State the full black-letter rule for the exception and break down its elements, please.
The court applied the main purpose exception. The rule states that the promise is outside the sominus if the promiser's leading object in making the promise was to secure some direct, independent economic advantage for himself. The elements are basically, 1, you have what looks like a suretyship promise, 2, the promiser gets some consideration or benefit from making the promise, and 3, crucially, the main purpose behind that promise was the promiser's own economic gain, not just, helping out the primary debtor.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply the first element, the existence of a suretyship promise?
That was straightforward. The shareholder promised the creditor he'd pay the corporation's debt if the corporation didn't. That's textbook suretyship. So initially, yes, it seems to fall within the statute. Element 1 met.
Understood. Now what about the second and third elements, focusing on the main purpose and the shareholder's economic advantage? This seems to be the core of the analysis.
Exactly. The court looked beyond the form of the promise. What was really going on? The shareholder made the promise primarily to prevent the creditor from suing his company. Such a lawsuit could have damaged the company's viability and, more importantly to him, threatened his personal investment and business reputation. So the court found his main purpose wasn't just generosity towards the company, it was protecting his own substantial financial stake. That was his leading object.
Ah, I see. So the benefit to him wasn't just indirect. Preventing the lawsuit directly protected his personal assets and standing.
Precisely. He gained a direct business advantage for himself.
And after analyzing all the elements, What was the court's final conclusion?
The court concluded the oral promise was enforceable. The main purpose exception applied. Because the primary benefit flowed to the shareholder himself, the statute's cautionary function wasn't needed. He was acting out of self-interest, fully aware of the implications.
That makes perfect sense. The why behind the promise matters more than the what's. Okay, let's shift gears completely now. Let's move into the Uniform Commercial Code, the UCC, specifically its rules for sales of goods worth $500 or more. How does the UCC handle writing requirements differently, especially for merchants?
Right, the UCC governs goods, and it generally reflects the faster pace of commerce. The basic rule, UCC Section 2201, subsection 1, is similar to common law. Contracts for goods priced at $500 or more generally need some writing. It has to indicate a contract was made, state a quantity, and be signed by the party you're trying to enforce it against. Pretty standard so far.
Okay.
But the UCC has a very powerful exception in subsection 2, specifically for merchants dealing with each other. It's a confirmatory memorandum rule.
The confirmatory memo. That's the one that can bind someone, even if they didn't sign anything, right? That seems to cut against the whole point of the statute of frauds. How does that work?
It does seem counterintuitive at first, but it's designed to prevent bad faith tactics between professionals. Here's the gist. If two merchants make an oral deal,
Okay.
and one merchant sends the other a written confirmation of that deal within a reasonable time, a confirmation that would be good enough to enforce against the sender if they were the one being sued.
Right, so it has quantity, indicates a contract.
Yes. And if the merchant who receives that confirmation has reason to know what's in it, and they don't send back a written objection within 10 days of receiving it.
10 days, that's fast.
Very fast. Then the statute of frauds is satisfied against the receiving merchant, even though they never sign a thing. Their silence after receiving the confirmation essentially validates the contract against them.
Wow. Okay, let's put that rule under the microscope with GPL treatment, LTVV Louisiana Pacific Corp. The facts, as I recall. A merchant seller and merchant buyer agreed orally on a big order of cedar shingles over $500. The seller then sent the buyer a signed confirmation memo. The buyer got it, read it, but never sent any written objection back within that 10-day window. Let's analyze GPL treatment. First, what are the legally dispositive facts?
Simple and direct. Oral agreement, goods over $500, both parties are merchants. One merchant sends a signed confirmation sufficient against itself. The recipient gets it, knows what it says, and crucially, fails to object in writing within 10 days.
And what was the core legal issue?
The issue was whether this oral contract for shingles was enforceable against the buyer, the merchant who received the confirmation but never signed it, specifically because they failed to object in time.
What rule of law did the court apply? Please state the full black-letter rule from UCC 22012 and break it down into its testable elements needed to bind the recipient.
Okay, the rule is UCC Section 2201, subsection 2. To bind the recipient, the one who didn't sign, 4 elements must be met. 1. The transaction must be between merchants. 2. A written confirmation that is sufficient against the sender must be received within a reasonable time. 3. The recipient must have reason to know its contents. And 4. The recipient fails to give written notice of objection within 10 days after they receive the confirmation.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply the first element, between merchants?
That was easy here. Both GPL and Louisiana Pacific were clearly businesses regularly dealing in lumber products, cedar shingles. They easily fit the UCC definition of merchant for this transaction. Element 1, check.
Understood. Now, what about the second and third elements concerning the sufficiency of the memo and the buyer's knowledge?
Also pretty clear. The seller's memo was signed by the seller, it mentioned the quantity of shingles, and it clearly indicated a contract for sale had been made. That makes it sufficient against the sender, element 2. And since the buyer received this document outlining their supposed deal promptly, they certainly had reason to know its contents, element 3. No dispute there.
Okay, so it really comes down to the final step, the fourth element, that 10-day objection window.
This was the make-or-break element. The evidence showed the buyer received the confirmation and simply did nothing in writing within those next 10 calendar days. No email, no letter, no fax saying, wait, we didn't agree to this, or these terms are wrong. Under the UCC 22012, that failure to object within the strict 10-day period operates as a substitute for the buyer's signature for statute of frauds purposes. Element 4 was met by their inaction.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded that the statute of frauds defense was overcome. The requirements of the confirmatory memorandum exception were fully met. Therefore, the oral contract was enforceable against the buyer even without their signature, all because they failed to object within that critical 10-day window.
A powerful illustration of how the UCC prioritizes efficiency and expects merchants to act promptly. Silence can bind you.
Absolutely. In the world of merchants under the UCC, you have a duty to respond quickly if you receive something you disagree with.
This has been incredibly insightful, really breaking down these complex rules. Before we finish, could you synthesize all this into a practical checklist, something our listener can use when they spot a potential statute of frauds issue on an exam or in practice?
Definitely. Here's an actionable diagnostic checklist for statute of frauds analysis. Step 1. Initial screen. Does the contract even fall into a potential SOF category? The main ones are interest in land, suretyship promises, contracts impossible to perform within 1 year, contracts for goods $500 or more under the UCC, and, less commonly, contracts in consideration of marriage. If it's not in one of these buckets, you're done. SOF doesn't apply.
Okay, first hurdle. What if it is in one of those categories?
Step 2. If it might be a 1-year rule issue, ask, do the contract's express terms make it impossible to fully perform within 365 days from formation? Remember the key distinction. Is early completion full performance, takes it outside the SOF, or merely an excuse for non-performance of a longer fixed term, keeps it inside the SOF? Think death in a for-life contract versus death in an 18-month contract.
Got it. Performance versus excuse. What about suretyship?
Step 3. If it looks like suretyship, a 3-party promise to answer for another's debt, immediately check for the main purpose exception. Ask, was the promisor's primary motivation to gain a direct personal economic advantage? If yes, the oral promise is likely enforceable, taken outside the SOBRA. If the motive was primarily altruistic or indirect, it probably stays within the SOBREF and needs writing.
Main purpose, self-interest.
Okay.
And the UCC.
Step 4. If it's a contract for goods $500 or more, UCC, first look for a writing signed by the party resisting enforcement that indicates a contract and has a quantity. If there isn't one, immediately pivot to the major exceptions. Check the confirmatory memo exception, UCC 221-2. Is it between merchants? Did one send a sufficient confirmation? Did the recipient fail to object in writing within 10 days? If yes to all, SOPREF is satisfied against the recipient. Also consider special manufacture, goods specially made for the buyer, not suitable for others, substantial start made, or part performance admission, enforceable only for goods accepted paid for or quantity admitted in court pleadings.
That framework is incredibly helpful, thank you. I think the big takeaway is clear. The statute of frauds tries to prevent fraud through requiring writings, but the exceptions are so numerous and, frankly, complex, like that main purpose rule or the lightning-fast confirmatory memo deadline, that you really have to be vigilant. Oral agreements can absolutely bite you or save you, depending on these details.
That's exactly right. And let me leave you with one final, maybe provocative thought to chew on, especially regarding the UCC. The UCC has that admission exception we briefly mentioned. An oral contract for goods over $500 can become enforceable if the party denying it admits in their pleadings, testimony, or otherwise in court that a contract for sale was made. This creates a serious ethical and strategic tightrope for a defendant during litigation. If you genuinely made an oral deal, do you deny its existence under oath early on, hoping the other side can't prove it otherwise and relying on the self-defense? Or do you risk being forced through discovery or cross-examination to admit facts that satisfy the admission exception, thereby destroying your own defense? It really highlights the tension between formal legal defenses and the underlying reality of agreements.